Welcome to this presentation reviewing the 100-year-old statutory functions and bodies of the Department of Justice. The Department of Justice was one of 11 departments of state constituted by the Ministers and Secretaries Act 1924, in which act those departments were also defined. Section 1 of the 1924 Act provides for the establishment of the 11 departments of state in the Irish Free State specified in the 11 subparagraphs which are contained in that section. Subparagraph 3 of that first section provides for the establishment of the Department of Justice, which shall comprise the administration and business generally of public services in connection with law, justice, public order and police, and all powers, duties and functions connected with the same. How, you might well ask, might it have come about that justice was included in that subparagraph as the second of the public services in connection with which the Department of Justice was to comprise of the administration and business generally? While that subparagraph provides that the head of the department is to be styled the Minister for Justice, prior to the enactment of the Ministers and Secretaries Act 1924, the minister so to be styled was styled the Minister for Home Affairs, as we see from the 10th part of the schedule to the Act. Kevin O'Higgins was the first Minister for Justice appointed under the Act, and he had been the Minister for Home Affairs when he was appointed Minister for Justice. And when the bill that subsequently became the Ministers and Secretaries Act 1924 was being drafted, the ministry being provided for in the bill was being styled the Ministry of Home Affairs and not the Ministry of Justice. In a draft of what was then entitled the Ministries Bill, issued by the parliamentary draftsman on the 28th of December 1922, we have a version of what became subparagraph 3 of section 1 of the Ministries and Secretaries Act 1924, which early version provided that the Minister of Home Affairs shall have charge of and be responsible to the Dáil for the administration of public services relating to law, justice, police, and all home affairs not specifically assigned to any other ministry. It is the Department of Home Affairs rather than the Minister of Home Affairs that is provided for in the version of that provision which was circulated just over 6 months later on the 9th of July 1923, where we find public services in connection with law, justice, public order and police, and all powers, duties and functions connected with the same. That is, a wording closer to that contained in the later subparagraph 3 of the 1924 Act. Exactly 4 months later, in the draft of the 9th of November 1923 sent to the Dáil for printing, we find Department of Justice substituted for Department of Home Affairs, with public services in connection with law, justice, public order and police given in that order, as it was given when the department was being styled the Department of Home Affairs rather than the Department of Justice. In fact, the Minister's Bill's wording, with law followed by justice, goes back to the schedule to the Provisional Government Transfer of Functions Order 1922, on which schedule the parliamentary draftsman Arthur Matheson based his draft provisions on the duties and sphere of action of the 11 ministers subsequently enacted in Section 1 of the Ministers and Secretaries Act 1924, as was stated by Matheson in his memorandum accompanying his draft of the 28th of December 1922. In the table contained in the schedule to that 1922 order, the administration of services in connection with law, justice, police and home affairs generally was the wording implied in the column on the functions assigned to the Ministry of Home Affairs, with justice following law as it does in the provision in the 1924 Act in relation to the functions of the Department of Justice. Note, however, that as early as the 1st of January 1923, the law officer of the Irish Free State, later Attorney General, Hugh Kennedy, referred in his covering letter with that memo from the draftsman and the draft of the bill to a Ministry of Justice, which was not provided for in the 1922 draft of the bill, but which, he states, could easily be done on the same lines as the ministries outlined in that draft. Speaking in the Dáil on the second stage of the Ministers and Secretaries Bill 1923 on the 16th of November 1923, the President of the Executive Council, William T. Cosgrave, stated that the alteration from Ministry for Home Affairs to Ministry of Justice was made at the request of the Department for Home Affairs itself, that the term Ministry for Home Affairs was very wide in description and indefinite in its interpretation, and that it might conceivably connote the whole of the internal organisation of government, with the exception of the Ministry for Finance. 10 years after the establishment of the Department of Justice, Nicholas Manser noted that the Ministry for Justice represented the achievement of reforms so frequently urged upon the Home Office in England. In the 1918 report of the Machinery of Government Committee, it was considered that a strong case was made out for the appointment of a Minister for Justice, noting the difficulty under the then current system of embarking on legal reform. Note finally in relation to justice following law in the provision in the Ministers and Secretaries Act 1924 that in styling the Minister for Justice an Tara Dlí agus Ceart in Irish in that 1924 Act, both law Dlí and justice Ceart, which has the form Ceart in expressing of justice, is incorporated in that Irish title. In the Irish name of the Department of Justice, justice is similarly expressed as both law and justice, that is, dlí, and the genitive of ceart, ceart, that is, an rainn dlí agus ceart. We see how ceart alone translates justice in the direct translation of justice in the Irish translation of that subparagraph 3 of the first section in the 1924 Act. Both the name of the Department of Justice and the title of the Minister for Justice were changed to that of the Department of Justice, Equality and Law Reform and the Minister for Justice, Equality and Law Reform, respectively, by the Justice Alteration of Name of the Department and Title of Minister Order 1997. That order was made by Taoiseach Bertie Ahern on the 8th of July that year. That 1997 alteration of name of department and title of minister order was made by the government in exercise of the powers conferred on them by a provision contained in the Ministers and Secretaries Amendment Act 1939 that the government could, by order, alter the name of any department of state and the title of any minister having charge of a department of state. 3 years later, by the Justice, Equality and Law Reform, Alteration of Name of Department and Title of Minister Order 2010, the name of the Department of Justice, Equality and Law Reform was changed to that of the Department of Justice and Law Reform, and the title of the Minister was changed to that of the Minister for Justice and Law Reform. The following year, the name of the Department of Justice and Law Reform was changed to that of the Department of Justice and Equality, and the title of the Minister for Justice and Law Reform was changed to that of the Minister for Justice and Equality by an order of the government under then Taoiseach Enda Kenny. The name of the department and the title of the minister were returned to those of the Department of Justice and the Minister for Justice respectively, that is, the original 1924 name and title, by the Justice and Equality Alteration of Name of Department and Title of Minister Order 2020, made by the government under Taoiseach Micheál Martin in October 2020, with Helen McEntee, who had been appointed Minister for Justice and Equality on the 27th of June of that year, becoming Minister for Justice on the 1st of November 2020. Those alterations of the name of the department and title of minister in 1997 and 2011 would have entailed, at the very least, a new focus regarding the functions of the department as laid down 73 and 87 years previously, respectively, in subparagraph 3 of Section 1 of the Ministers and Secretaries Act 1924. That subparagraph has, however, never been amended over the course of the 100 years since the enactment of that Act, during which period very specific and varied functions have both been laid down in various statutes and statutory orders and instruments for performance by the Department of Justice and Minister for Justice and have been performed by that Department and Minister. In a table of the functions of the Minister for Justice appendixed to the November 2022 edition of the Department of Justice's Data Protection Policy, immigration is listed in second place after provision of a court service. While accounts of the state's legislation on immigration usually commence with the Aliens Act 1935, in section 2 of which alien is defined as a person who is not a citizen of Searstad or the Irish Free State, in fact, just 9 months after the enactment of the Ministers and Secretaries Act 1924, the Minister for Justice of the Irish Free State was given extensive functions and powers in relation to immigration by the Aliens Order 1925. That order was made by the first Governor-General of the Irish Free State, Tim Healy, acting on the advice of the Executive Council on the 22nd of January of that year. We see that under section 15.1 it was the Minister for Justice who was to appoint the immigration officers. We see under subsection 2g of section 1 that the Minister could prohibit an alien from landing, and under subsection 2h that the Minister could prescribe requirements by general or special instructions as regards an alien landing in the Irish Free State. And under section 3.3, an alien arriving at any port other than an approved port could be detained in such manner as the Minister might direct. That 1925 order contains similar provisions to provisions contained in the earlier British 1920 Aliens Order, likewise made under the Aliens Restriction Act 1914 as amended by the Aliens Restriction Amendment Act 1919. Provisions such as the maintenance of a central register of aliens, provided for in section 9.1 of the Irish 1925 order. Under section 10, the Minister had power to impose on any alien such restriction as to residence, reporting to the police and registration as the Minister deemed to be necessary in the public interest. And under section 11, the Minister could make a deportation order requiring an alien to leave and remain out of the Irish Free State. Many similar provisions are contained in the better known aforementioned Aliens Act 1935, particularly in section 5 under the margin title Control of Aliens. In more recent years, we have had further primary legislation such as the Immigration Acts of 1999, 2003 and 2004, as well as the Refugee Act 1996 and the International Protection Act 2015. Writing just 10 years after the constitution of the Department of Justice, Nicholas Mansarg referred to what he described as the somewhat heterogeneous duties of the Minister for Justice, which extended, he stated, from a control of alien immigration to a control over the sale of liquor, over betting and lotteries, and comprised control over the importation of firearms and the storage of explosives, in addition to the administration of the various censorship acts being under its jurisdiction. Such duties were to continue and be augmented over the following decades into the 21st century. The Very Short Gaming Bill 1923, initiated in mid-November of that year, was sponsored by the Minister for Home Affairs, and the Gaming Act 1923 commenced on enactment on the 23rd of December. The Comprehensive Gaming and Lotteries Bill 1955 was initiated by the Minister for Justice on the 31st of March that year, with the Act commencing on the 1st of March the following year. Section 4.1 of the Act, for example, provides that no person shall promote or provide facilities for any kind of gaming in which the chances of all the players, including the banker, are not equal. Section 21.1 provides that no person shall promote or assist in promoting a lottery, but provision is made for certain private lotteries, for lotteries at dances and concerts, at carnivals and other events that are not unlawful, and for lotteries under permit or licence. It was the Minister for Finance, however, that sponsored the National Lottery Act 1986. The Minister for Justice and Equality made certain amendments to both the Gaming and Lotteries Act 1956 and the Betting Act 1931 in the Gaming and Lotteries Amendment Act 2019. And it was the Minister for Justice who introduced the Gambling Regulation Bill 2022, which, as passed by both houses of the Oireachtas, was signed into law by the President on the 23rd of October 2024, and which provides for the establishment of the Gambling Regulatory Authority of Ireland for the purposes of licensing and regulating betting, gaming and certain lotteries. The very short Coroner's Qualification Bill 1923 was sponsored by the Department of Home Affairs, and, when enacted, the Coroner's Qualification Act 1924 was an act to declare certain persons who have resigned from the office of Justice of the Peace to be qualified to be appointed to be coroners, and to validate the appointment as coroners of certain persons who had not the statutory qualifications for such appointment. The Coroner's Amendment Act 1927 provided inter alia that the Minister for Justice may make rules for regulating the practice and procedure at or in connection with inquests and post-mortem examinations. Another Amendment Act followed 20 years later. The law relating to coroners and the coroner's inquests was amended and consolidated by the Coroners Act 1962, to which many amendments were made in the Coroners Amendment Act 2019, and which was further amended by the Coroners Amendment Act 2024. The Intoxicating Liquor Bill 1923 was sponsored by the Department of Home Affairs with Kevin O'Higgins as Minister, and, as passed, the Intoxicating Liquor Act 1924 was an act to amend the law relating to the sale of intoxicating liquor. The Department of Justice, with Kevin O'Higgins as Minister, sponsored the Intoxicating Liquor General Act 1924, under Section 9(1) of which it was provided that the Minister for Justice may, by order, prescribe the sizes of the bottles in which any specified intoxicating liquor may be sold. Early the following year, Minister O'Higgins established the Intoxicating Liquor Commission to inquire into and report to the Executive Council on the question of whether the existing number of licences for the sale of intoxicating liquor was in excess of reasonable requirements, and to make recommendations by which an adequate reduction might be effected on an equitable basis. 3 years later, the Minister for Justice sponsored the Intoxicating Liquor Act 1927 to enable the number of licences for the sale of intoxicating liquor to be reduced by the abolition from time to time of certain such licences. The Minister for Justice subsequently sponsored various other intoxicating liquor acts over the past century, including, for example, the Intoxicating Liquor Act 1988, Section 40 of which provided that the Minister might by regulations provide for the issue to a person of or over the age of 18 years of an age card specifying the age of the person. The Firearms Temporary Provisions Act 1924 was sponsored by the Department of Home Affairs and was an act to make provision during a limited period for the placing of restrictions on the import, manufacture and possession of and dealing in firearms and other weapons and ammunition, renewing expired provisions contained in the Public Safety Act 1923, which were further continued for a limited period the following year by the Firearms Temporary Provisions Continuance Act 1925. Later that year, the Minister for Justice sponsored the more substantial Firearms Act 1925, an act to place restrictions on the possession of firearms and other weapons and ammunition, in which act firearm is defined as a lethal firearm or other lethal weapon of any description from which any shot, bullet or other missile can be discharged. That act was amended and extended by the Firearms Acts 1964 and 1971, with the Firearms Proofing Act 1968 being an act to provide for the proofing by the Institute for Industrial Research and Standards of certain firearms. The Firearms and Offensive Weapons Act 1990 is an act to amend and extend the Firearms Act 1925 to 1971 to control the availability and possession of offensive weapons and other articles. That was followed by the Firearms Temporary Provisions Act 1998 and the Firearms Certificates for Non-Residents Act 2000, both of which were acts to provide for amendment of the provisions governing the limitations and restrictions for the granting of firearms certificates under Section 3 of the Firearms Act 1925. Over twice as many regulations or orders were made by the Minister for Home Affairs or Ministers for Justice over the century, following regulations made on the 9th of May 1924 by the Minister for Home Affairs pursuant to Section 2 of the Firearms Temporary Provisions Act 1924. And while it appears that no primary legislation was enacted by the state in relation to explosives, many statutory instruments on explosives were made by or on the recommendation of Ministers for Justice from 1935 on, with Section 3 of the Explosives Act 1875, Adaptation Order 1935, providing that references to the Secretary of State in the Explosives Act 1875 were to be construed as references to the Minister for Justice. A recent such statutory instrument made is the European Union making available on the market and supervision of explosives for civil uses Amendment Regulations 2024, which was made by Minister Helen McEntee on the 28th of August 2024. At the second stage of the Summertime Bill 1923 in the Dáil in March of that year, Minister for Home Affairs Kevin O'Higgins stated that the case for the bill is based on national economy in the broadest sense, the saving of light and fuel, and that the case against the bill was that the agricultural community would have to do a sum in subtraction every time they looked at their watches. The Summertime Act 1923 was followed by the Summertime Acts 1924 and 1925, under Section 3 of which latter act the Minister for Justice was given power to alter summertime. That act was later repealed by the Standard Time Act 1968, an act to establish the time for general purposes at 1 hour in advance of Greenwich Mean Time throughout the year, which act was itself amended by the Standard Time Amendment Act 1971, an act to provide for a period which shall be known as winter time, and during which the time for general purposes in the state shall be Greenwich Mean Time. Both of those acts were sponsored by the Minister for Justice, who still today issues the notice each year in relation to clocks going forward and back 1 hour for summertime and wintertime, respectively. As regards censorship, responding in the Dáil on the 3rd of November 1925 to a question in relation to the importation of indecent literature into the state, Kevin O'Higgins stated that there were ample powers under the then existing law to deal with the sale and distribution of obscene literature, and that he was not yet satisfied that the state could usefully interfere to decide what the public might or might not read with propriety. However, he stated that he was prepared to set up a small departmental committee to consider and report on the proposals of those who thought that a practical remedy might be found. On the 12th of February 1926, he appointed the Committee on Evil Literature to consider and report whether it was necessary or advisable in the interest of the public morality to extend the existing powers of the state. It was the then Minister for Justice, James Fitzgerald Kenny, who over 2 years later, on the 19th of July 1928, introduced the Censorship of Publications Bill 1928 in the Dáil, Kevin O'Higgins having been assassinated 12 months earlier on the 10th of July 1927 while walking to a Sunday noon mass at his local church in Booterstown, Dublin. As stated in the long title of that 1928 bill, which was enacted the following year as the Censorship of Publications Act 1929, that act was principally an act to make provision for the prohibition of the sale and distribution of unwholesome literature, and for that purpose to provide for the establishment of a censorship of books and periodical publications. The 1929 Censorship of Publications Act provided for the establishment of a Censorship of Publications Board, consisting of 5 fit and proper persons appointed by the Minister to be members of the board. Section 6.1 of the Act provided that whenever a complaint was made to the minister that a book was indecent or obscene or advocated the unnatural prevention of conception or the procurement of abortion, the minister might refer such complaint to the board. The word indecent was, according to the definition of it in the Act, to be construed as including suggestive of or inciting to sexual immorality or unnatural vice, or likely in any other similar way to corrupt or deprave. Following a negative report of the committee on the book, the minister could prohibit the sale and distribution in the state of the book. Similar provisions were contained in the following section of the Act in relation to periodicals. The Censorship of Publications Appeal Board was provided for by the Censorship of Publications Act 1946. 21 years later, the Censorship of Publications Act 1967 provided for the expiration of certain prohibition orders under the two earlier censorship acts and the removal of the time limit imposed by the 1945 Act in respect of certain appeals to the Appeals Board. Film censorship had been provided for by the Irish Free State earlier than censorship of publications. The Censorship of Films Act 1923, an act to provide for the official censoring of cinematograph pictures, was sponsored by the Minister for Home Affairs. The Office of Official Censor of Films was established under that Act, with provision being made in Section 2 of the Act for the Minister for Home Affairs to appoint a fit person to the Office of Official Censor and under Section 3 for the Minister to appoint fit persons to be members of the Censorship of Films Appeal Board provided for in that section. The following section provided for the Minister's appointment of persons to be officers of the Official Censor and of the Appeal Board, respectively. Sections 5 to 7 of the Act provided, in effect, for either the banning or the cutting of films considered to be indecent, obscene, or blasphemous, or contrary to or subversive of public morality. Section 12.1 of the Act provided for the Minister for Home Affairs to make regulations for regulating the conduct of the Office of the Official Censor, the making of applications to him, the granting of certificates by him, and the bringing of appeals to the Appeal Board. On the 8th of January 1924, Kevin O'Higgins, Minister for Home Affairs, made an order under that section that every renter shall, before the 22nd of January 1924, furnish to the Official Censor of Films, 24 Kildare Street, Dublin, particulars of all contracts entered into by him for the letting or hiring of pictures for exhibition. As Minister for Justice, he made two orders under that section the following year, the Censorship of Films No. 1 Order 1925 and the Censorship of Films No. 2 Order 1925. The following year, he made the Censorship of Films Exhibition of Censors Certificate Regulations 1926. Following the assassination of O'Higgins in 1927, censorship of films regulations were made by various ministers for justice under that Section 12 of the 1923 Act, including by the then Minister for Justice Charlie Haughey in 1962, who made the Censorship of Films Exhibition of Censors Certificate Amendment Regulations 1962. The latest such regulations made were the Censorship of Films Exhibition of Censors Certificate Amendment Regulations 1983, which provided for an increase in the fine for the non-exhibition of the film censor certificate, and which were made by the then Minister for Justice, Michael Noonan. The Video Recordings Act 1989, sponsored by the then Minister for Justice, provided inter alia for the certification and classification of video works and for the prohibition of supply and possession of video recordings of uncertified video works. And under the Civil Law Miscellaneous Provisions Act 2008, the name of the Official Censor of Films was changed to Director of Film Classification, and the name of the Office of Official Censor of Films was changed to the Irish Film Classification Office, and functions to this day as a statutory body established under the aegis of the Department of Justice in 1923. Such is not the case as regards bodies which are listed in the second part of the schedule to the Ministers and Secretaries Act 1924, which part of the schedule is referred to in subparagraph 3 of section 1 of that Act. Like subparagraph 3 of the Act, Part 2 of the schedule is based on the Schedule to the Provisional Government Transfer of Functions Order 1922, as we see even more clearly when we compare that part with the Parliamentary Draftsman's December 1922 draft of it. The first board mentioned in that second part of the schedule to the 1924 Act is the General Prisons Board for Ireland, which was established by the General Prisons Ireland Act 1877 and which was based in Dublin Castle under the British administration. The board was dissolved by Section 3 of the General Prisons Board Transfer of Functions Order 1928. That order was made under Section 9 of the Ministers and Secretaries Act 1924, which provided that it was lawful for the Executive Council to dissolve any Board of Commissioners or statutory body to which that section applied. Section 4 of that 1928 Transfer of Functions Order provided that all the jurisdictions, powers, duties and functions of the General Prisons Board be transferred to and conferred and imposed on the Minister for Justice. 71 years later, in 1999, the then Minister for Justice, Equality and Law Reform, John O'Donoghue, established the Irish Prison Service, which is a non-statutory body. As stated on its website, the Irish Prison Service operates as an office of the Department of Justice. The Registrar of District Court Clerks, listed after the General Prisons Board for Ireland in the second part of the schedule to the 1924 Act, was abolished by Section 50 of the Courts Officers Act 1926, and such of the duties of that office as continued to exist were to be discharged by the Principal Officer of the Department of Justice or by such other officer of the Minister as the Minister from time to time directed. Under the Court Service Act 1998, the Court Service, an independent state agency, was established to manage the courts and support the judiciary. Functions of the Minister for Justice under Acts such as the Court Officers Act 1926, 1945 and 1951 and the Courts of Justice Acts 1936 and 1953 became functions of the Court Service, which is required by the Act to provide an annual report of its activities to the Minister. The Court Service has its head office at Phoenix House, Smithfield in Dublin. The Public Records Office is the next body listed in the second part of the schedule to the 1924 Act. That office was established under the Public Records Ireland Act 1867 to acquire administrative, court and probate records over 20 years old. The Public Records Office building was located at the Church Street side of the Four Courts complex. It was seized during the Civil War, with the repository building being destroyed by fire in June 1922, along with most of the records, some dating back to the 13th century. The office continued to function under the Department of Justice, however, for 60 years, as we see here, for example, how the fees chargeable from the 1st of April 1982 for the use of records in that office and for making copies of records was prescribed by an order made by the then Minister for Justice, Jim Mitchell, in March 1982. Under Section 3.1 of the Arts and Culture Transfer of Departmental Administration and Ministerial Functions Order 1984, the functions vested in the Minister for Justice in relation to the Public Records Office by the 1924 Act were transferred to the Taoiseach. And under Section 5.1 of the Order, the administration and business in connection with the exercise, performance or execution of said functions was transferred to the Department of the Taoiseach. 2 years later, under the National Archives Act 1986, the National Archives of Ireland took over the functions of both the Public Records Office of Ireland and the State Paper Office, or as stated in the Irish State Administration database in relation to the Public Records Office, death by merge into the National Archives. The headquarters of the National Archives moved from the Four Courts complex to Bishop Street in 1992, and the former Public Record Office building is now occupied by the Court of Appeal to the front and the National Archives to the rear and basement. We now move on to the next two bodies listed in the second part of the schedule to the Ministers and Secretaries Act 1924. They are the Registry of Deeds and the Land Registry. The Registry of Deeds was an office established by the Registration of Deeds Act 1707 to provide a voluntary system of registering property transactions. Initially, it was located at Dublin Castle, moving to Inns Quay near the Four Courts in 1805. It moved to its current location at the top of Henrietta Street alongside King Lynn's in 1832. The current system of land registration dates from the Land Registry Act 1862. The central office of the Land Registry, as provided for in the Registration of Title Act 1964, was located in Chancery Street, in what is now part of the Four Courts complex, with the Four Courts to the south and the Public Records Office to the west. Both the Registry of Deeds and the Land Registry merged into the Property Registration Authority, which was established by the Registration of Deeds and Title Act 2006. The Act provided, however, that the members of the authority were to be appointed by the Minister, who was also to designate one of them as its chairperson. And Section 5 of the Act provided for expenses incurred by the Minister in the administration of that Act and the Registration of Title Act 1964. Under the Property Registration Authority Transfer of Departmental Administration and Ministerial Functions Order 2017, however, the functions vested in the Minister for Justice and Equality by or under both the Registration of Deeds and Title Act 2006 and the Registration of Title Act 1964 were transferred to the Minister for Housing, Planning and Local Government. Under the Tailteann Éireann Act 2022, sponsored by the Minister for Housing, Local Government and Heritage, provision was made for the transfer of all functions of the Property Registration Authority and of Ordnance Survey Ireland to Tailteann Éireann. We now have a Tailteann Éireann nameplate in place of the Registry of Deeds nameplate on the building in the grounds of the King's Inns and on the building in the Four Courts complex. Looking at the final body in the 1924 schedule, a body corporate known as the Commissioners of Charitable Donations and Bequests for Ireland was created under the Charitable Donations and Bequests Ireland Act 1844. The purpose of the Commissioners was to ensure the most effectual application of charitable donations and bequests in Ireland. They were successors of the first Board of Commissioners established in 1800. The Charities Act 1961, sponsored by the Minister for Justice, provided that the Commissioners should continue in being and consolidated and amended the statutory provisions that had governed their powers and functions. The powers of the Commissioners were extended by the Charities Act 1973, which amended the Charities Act 1961 to allow for the incorporation of charity trustees. The Charities Act 2009 provided for the dissolution of the Commission of Charitable Donations and Bequests for Ireland and the establishment of the Charities Regulatory Authority, also described as the Charities Regulator. All functions that had been vested in the Commissioners were transferred to the authority. The Commissioners of Charitable Donations and Bequests for Ireland ceased to exist from the 16th of October 2014. Under the Charities Transfer of Departmental Administration and Ministerial Functions Order 2017, the functions vested in the Minister for Justice and Equality by or under the Charities Acts 1961 and 1973 and the Charities Act 2009 were transferred to the Minister for Rural and Community Development, and it is stated on the website of the Charities Regulatory Authority that the authority members were appointed by the Minister of State for the Department of Rural and Community Development and the Minister for Rural and Community Development. On the 26th of October 1938, Sean O'Muinechan, or John Minahan, Assistant Secretary in the Department of Finance, wrote to the then Secretary of the Department of Justice, Stephen Roach, requesting a full revised list of the particular branches of administration assigned to the Department of Justice, noting that the details in the schedules to the Ministers and Secretaries Acts 1924 and 1928 were not up to date and were incomplete in some respects. He pointed out, for example, that the term police in the second part of the schedule to the 1924 Act might be replaced by An Garda Síochána. While the new police force, the Civic Guard, which was formed by the Irish government on the disbandment of the Royal Irish Constabulary, or the RIC, in early 1922, had been renamed the Garda Síochána on the 8th of August 1923, it wasn't until 1925, that is, following the enactment of the Ministers and Secretaries Act in 1924, that the Dublin Metropolitan Police merged with the Garda Síochána. In his response, 2 months later, the Secretary-General agreed with Minahan's observation that the term police should be replaced by the term Garda Síochána. Responding to Sean O'Muinechan's request in his October letter that the department also furnish a statement showing the boards, commissions and other bodies charged by statute with duties coming within the scope of the functions assigned to the Department of Justice, Stephen Roach noted that court rule-making committees were appointed under various sections of the Courts of Justice Act 1936. In fact, the first 36 sections of the Courts of Justice Act 1924 were commenced only 3 days after the commencement date of the Ministers and Secretaries Act 1924, with the Bill for the Courts of Justice Act passing both houses of the Oireachtas on the 3rd of April 1924, 6 days before the Bill for the Ministers and Secretaries Act passed those houses. As the long title of the Courts of Justice Act 1924 states, it is an Act for the establishment of courts of justice pursuant to the Constitution of Saoirstát Éireann and for purposes relating to the better administration of justice, and that fundamental act contains 104 sections. The Minister for Home Affairs was given functions under that Act in relation to the making of rules of court. Note that the Act was not sponsored by the Minister for Home Affairs, but by the President of the Executive Council, William T. Cosgrave, who, as noted earlier, also sponsored the Ministers and Secretaries Act 1924, and who stated in a letter dated the 29th of January 1923, which he addressed to the Chairman of the committee set up by the Government to advise it as to how best to provide for the setting up of national courts of justice in the Irish Free State, that there is nothing more prized among our newly won liberties than the liberty to construct a system of judiciary and an administration of law and justice according to the dictates of our own needs and after a pattern of our own designing. As regards the offices of the Courts of Justice referred to in the second part of the Schedule to the Ministers and Secretaries Act 1924, just 2 years following the publication of that Act, the Court Officers Act 1926 was enacted, which Act was an Act to establish and regulate the offices and officers to be attached to the several Courts of Justice and the judges of those courts and for other purposes connected therewith, as stated in its long title. No mention is made of the Ministers and Secretaries Act 1924 in that 1926 Act. As regards the qualification in the 1924 schedule regarding all the offices of the Courts of Justice, save insofar as the same are reserved to the Executive Council, Section 3.3 of the 1926 Act provided that the Master of the High Court and the taxing masters be appointed by the Executive Council, whereas principal officers attached to the High Court, the Supreme Court and the Chief Justice were to be appointed by the Minister for Justice, and Section 35.2 of the Act provided that every county registrar be appointed by the Executive Council. The Court Officers Act 1926 was sponsored by the Minister for Justice and contained 66 sections, many of which, as just noted, provided for specific functions of the Minister, including the determination of how many officers, clerks, messengers, criers and servants be employed as the Minister from time to time determined. Other functions of the Minister provided for in the Act included the nomination of officers in the Central Office to be registrars of the High Court, the appointment of District Court clerks, and the general direction of the Master of the High Court, the Registrar of the Supreme Court, and the Register to the Chief Justice in regard to all matters of general administration. And, as noted earlier, the Registrar of District Court Clerks listed in the second part of the schedule to the 1924 Act was abolished by Section 50 of the Court Officers Act of 1926, and such of the duties of that office as continued to exist were to be discharged by the Principal Officer of the Department of Justice or by such other officer of the Minister as the Minister from time to time directed. Secretary Roach, in his response to Assistant Secretary Moynihan, also suggested in relation to censorship that both the Official Censor of Films and Censorship of Films Appeal Board and the Censorship of Publications Board might be added to the second part of the schedule to the 1924 Act. Roach referred to the General Prisons Board for Ireland having been dissolved by the General Prisons Board Transfer of Functions Order 1928, as we have already noted, and stated that the reference to the General Prisons Board for Ireland should therefore be deleted from the second part of the schedule to the Act. No such deletion or proposed additions have ever been made by way of amendment of the second part of the schedule to the Act, nor, as stated earlier, has paragraph 3 of the first section of the Act ever been amended. Article 50 of the 1937 Constitution, that's the current Constitution, provides that the laws in force in Searstart Éireann immediately prior to the date of the coming into operation of that Constitution continue to be of full force and effect until the same or any of them have been repealed or amended by enactment of the Oireachtas. The schedule in the 1924 Act is specifically mentioned in relation to the Departments of State given as public bodies for the purposes of the Freedom of Information Act 1997. Following the list of the Departments of State in subparagraph 1 of paragraph 1 of the first schedule to that Act, it is stated in paragraph 4 that a reference in that subparagraph to any particular Department of State shall be construed as a, including a reference to a body, organisation or group specified in relation to that Department of State in the schedule to the Ministers and Secretaries Act 1924, and b, not including any other body, organisation or group. We find a similar construction in both the Official Languages Act 2003 and the Freedom of Information Act 2014. A familiar rule of interpretation is that the inclusion of one thing implies the exclusion of another, a legal principle expressed in Latin as expressio unius est exclusio alterius. It is noteworthy how, in listing the Department of Justice in the Freedom of Information Act 1997, the Probation and Welfare Service is included with the title of the department, that is, the Department of Justice including the Probation and Welfare Service. Prior to being styled the Probation and Welfare Service in 1979, the service had been styled the Welfare Service of the Department of Justice in 1970. A rebranded probation service was launched in 2006 by the Minister for Justice, Equality and Law Reform with a new management structure under a director. Section 13(1) of the Criminal Justice Community Service Amendment Act 2011 provided that the Probation and Welfare Service was to be known as the Probation Service. Staff of the Probation Service are officers of the Minister according to the definition of the service in the Policing, Security and Community Safety Act 2024. It is stated on the Probation Service's website that the service is an agency within the Department of Justice. It has its head office in Haymarket, Smithfield in Dublin. The foundation for probation work in Ireland is the Probation of Offenders Act 1907, which is the legal instrument that provides for statutory supervision of offenders in the community. Following its enactment and on the foundation of the Irish Free State in 1922, the probation staff in the Dublin City Courts comprised one official probation officer, Miss Dargan, assisted by an unpaid volunteer, Miss O'Brien. In 2024, the Probation Service's 493 staff includes 248 probation officers. Like the Probation Service, Immigration Service Delivery on Burr Quay, just down the Liffey from O'Connell Street, is a non-statutory service. Unlike the International Protection Office, an office within Immigration Service Delivery located on Lower Mount Street, Dublin 1, which is responsible for examining and processing applications for international protection under the International Protection Act 2015. As of the 21st of October 2024, there were 3,416 staff in the Department of Justice, including agencies, 2,295 in the Core Department, and 1,349 in Immigration Service Delivery. 59% of the Core Department are in Immigration Service Delivery, and 39% of the department as a whole. We get an idea of the level of amendment necessary to the second part of the schedule to the 1924 Act if that part were to include bodies and offices under the aegis of the department today, by looking at the bodies and agencies graphically portrayed by their logos in an appendix to the 2021 annual report of the department. A corresponding appendix is contained in the 2022 and 2023 annual reports. On the 1st of March 1939, Sean O'Muinechan, John Moynihan, sent a preliminary draft of a general scheme of a bill to the Attorney General, framed on the assumption that the Ministers and Secretaries Acts 1924 and 1928 would be repealed in toto, and that the new bill would closely follow the lines of the Act of 1924. He indicated what sections might be reenacted, amended or omitted, as well as additional sections that might be considered. It was, as we saw at the beginning of the presentation, pursuant to the 1922 Constitution of the Irish Free State, contained in the first schedule to the Constitution of the Irish Free State Act 1922, that the Ministers and Departments of State were constituted in the Ministers and Secretaries Act 1924. Many of the amendments proposed by Sean O'Muinechan in 1939 were aimed at bringing the Ministers and Secretaries Act 1924 into line with the recently enacted 1937 Constitution. As regards subparagraph 1 of Section 1, for example, Sean O'Muinechan suggested that the Department of the President of the Executive Council be amended to the Department of the Taoiseach. As regards subparagraph 3, he suggested that Executive Council be amended to Government and that an Executive Minister be amended to a Minister, the need for distinguishing between a Minister and an Executive Minister having disappeared under the new Constitution. No such amendments were contained in the Ministers and Secretaries Amendment Bill 1939, initiated on the 27th of September that year, which bill was principally directed to giving retrospective effect to the establishment of a Department of Supplies earlier that month due to conditions created by the outbreak of World War II. The Ministers and Secretaries Amendment Act 1939 did, however, provide in Section 6.3 that whenever any particular power, duty or function was then or was thereafter conferred or imposed by statute on a Department of State, the administration and business in connection with the exercise, performance or execution of such power, duty or function was to be deemed to be allocated to that Department of State. In the Dáil, on the second stage of the Ministers and Secretaries Amendment Bill 1939, William T. Cosgrave stated that, as that was the third act dealing with ministers and secretaries, it might have been thought well, in connection with matters of that kind, to codify the law. In response, the then Taoiseach, later President, Sean T. O'Kelly, who had introduced that 1939 bill, stated that there was under consideration for some time a bill to codify all the legislation up to then with regard to ministers and secretaries, and to bring it into line with the changes that had taken place under the Constitution, and that he hoped that bill would soon see the light of day, no doubt referring to Sean O'Muonicon's proposed Ministers and Secretaries Bill, O'Muonicon having on the 1st of March 1939 also transmitted to the Secretary of the Taoiseach a copy of his memo to the Attorney General on his proposed new bill. 18 acts dealing with ministers and secretaries and 82 alteration of name of department and title of minister orders have been made to date, and no such legislation codifying all the legislation so far with regard to ministers and secretaries and bringing it into line with the changes that took place under the Constitution has been enacted. In his 1960 monograph on the functions of the Department of the Taoiseach, Maurice Moynihan, Secretary General of that department and brother of Sean O'Muonicon, outlines inter alia specific powers, duties and functions conferred on the Taoiseach by the 1937 Constitution, and also states that the provision about records in subparagraph 1 of Section 1 of the Ministers and Secretaries Act 1924 is expressed in such wide terms that it cannot possibly mean what it appears to mean. As stated earlier, that subparagraph 1 dealing with what is now the Department of the Taoiseach, like subparagraph 3 dealing with the Department of Justice, has never been amended. In 1966, in Macaulay versus the Minister for Posts and Telegraphs, Justice Kenny held that subsection 1 of section 2 of the 1924 Act was repugnant to the provisions of the Constitution, insofar as it required the fiat of the Attorney General to be obtained before legal proceedings could be validly instituted in the High Court against a Minister of State, disrespecting a right to have recourse to the High Court to assert and vindicate a legal right, which is one of the personal rights of the citizen referred to in Article 40, Section 3, subsection 1 of the current Constitution. Even though it is invalid having regard to the provisions of the Constitution, subsection 1 of Section 2 of the Ministers and Secretaries Act 1924 has never been repealed. A fitting commemoration of the Ministers and Secretaries Act 1924 would be the codification of all the legislation so far with regard to ministers and secretaries, enacting a consolidated and amended Ministers and Secretaries Act, a Ministers and Ministers of State Act. Consideration might also be given to setting up an interdepartmental committee on the draft of such a new bill, as was done in January 1923 in the case of the preparation of the Ministries Bill. Not alone was former Minister for Home Affairs, lawyer Eamon Duggan, then a minister without portfolio, on that committee, but so also on that committee was the then Secretary or Secretary General of that department, Henry Friel or Henry O'Friel, who became the first Secretary or Secretary General of the Department of Justice following the commencement of the Ministers and Secretaries Act 1924. Goramahagut.